A concerned citizen has written to Sarah Boone's judge, and we're going to go over the letter in today's video. Hello, Sofa Squad, and welcome back to the sofa. The sofa's back there, and the little new mascots, Bo, William, and Luke Connor, they are sleeping and rumbling around with a babysitter in the other room, if you will. They might make an appearance later, they might not. This is probably going to be a little bit of a short video. I wanted to do this one separately just because it didn't really fit in with some of the other stuff here. And what we're going to be talking about today is the case of Sarah Boone. We're revisiting this again. I know. It's coming up for trial October 7th. And my orange clerk, the place where they put all her documents and stuff like that. I was going through there and I saw this one. It came from, a concerned citizen, and I just wanted to read it and go through it and kind of discuss some of the points that they brought up and whatnot. And again, this is in relation to Sarah Boone. This person has written directly to the judge. And it says here at the top, August 27th, so this is like a minute ago, about a month ago, depending on when you see this. Defendant Sarah Boone, self-representation concerns. Dear Judge Kranick, and it lists the case and whatnot, the case number. And it says, I've been closely following developments in the defendant Sarah Boone's case, who is accused of second-degree M, and I find her predicament very troubling. I mean, so do we all, right? It continues to say, it is evident that Sarah Boone is a difficult inmate who, per your decision, has forfeited her right to counsel. It is an appropriate conclusion, for though the right to court-appointed counsel is constitutionally guaranteed. Yes, agreed. Okay. The defendant does not have the right to shop for one ad infinitum until she finds the right fit. There are, however, some concerns and considerations which I fear will jeopardize the defendant's right to a fair trial, which perhaps have never been raised before. We must first recognize, as you are personally well aware, that no person in the state of Florida, nor in any state of these United States, is allowed to legally perform the duties of an attorney without a legal law license for which one has to pass a bar examination. Now let's pause right there. I would question this. Now again, if you're new here, just know I'm not a lawyer, I'm not a cop, I'm not a therapist, I'm not a doctor, none of that fancy stuff. Only credentials we got is the sofa, some sass, and some self-diagnosed personality disorder. Okay, she's going to say that right now. Okay. But, so just know that. These are just my opinions. But reading this, I'm like, well, if that was the true, then why are people allowed to go pro se? Think about Darrell Brooks, right? So that part, I'm not sure if an attorney is watching. I'd be curious to know, the validity of this. So let's keep going. That simple fact underscores the depth of education, experience, and savvy which are necessary for an individual to represent another individual or entity. But of course, these are 21st century considerations which take into account the complicated world in which we live today, and which were not on any of the founding fathers' radars when the Constitution was first drafted. I mean, yes, this is true, right? This is an ever-evolving thing. Expecting a lay person to be able to competently represent themselves in 2024 and with no accommodations would be tantamount to expecting a lay person to perform medical surgery on themselves without any access to modern tools. I mean, yeah, I see where you're going with this, right? Immediately it makes me defensive though, because I'm like, yeah, but I mean, again, you're acting like he just plucked her out of, a nice little working relationship with the attorney and forced this on herself, right? But let's keep going. So, we would never allow such a thing under the law, let alone legally mandate that someone has forfeited their right to a doctor and must now perform surgery on themselves. This is completely different, right? I mean, I'm sorry, but the comparison falls out the window at this point. This would be considered inhumane and a violation of human rights. As such, no individual without a law license should be allowed to represent themselves, ever. Individuals who have the education and accreditation, although ill-advised, are a different matter. I see what they're saying, but at this point, I feel like this needs to go into the Dear Abby section, or what I'm saying, the opinion column of the paper. I'm probably aging myself with those things, but you get, where I'm going, okay? Okay, let's continue. Now, considering that we cannot simply alter the Constitution without much due process, and with this I'm not suggesting that Ms. Boone be afforded yet another lawyer, what consideration should be taken in order to properly afford her access to a fair opportunity at self-defense? If another counsel is not an option, frankly speaking, there is no other choice but to allow the defendant to have access to any and all materials necessary to aid in her defense, including a law library, a computer, limited internet access, an investigator, etc. The defendant must be allowed a secured space and anything else they might reasonably need in order to research their case, study a defense, and properly represent themselves. These considerations should be provided for any defendant choosing their right to self-defense. This should not be seen as going above and beyond treatment of other pro se defendants. It should be seen as the treatment for all pro se defendants. For to deny these things is a clear violation of human rights. Now, here's the thing, and this kind of goes back and forth with this a little bit, or my feelings do on it. Like, I get what they're saying, and I would understand it even more if this was someone who, on her first attorney, the judge came in and said, I don't like what's going on, you've lost the right to this. I mean, this was years and years of this. Now, it also kind of feels like this could be someone that Sarah's corresponded with or something like that, or that, clearly is aligning themselves with her. Now, on that note, yes, I do also look at it like, okay, if someone's going to go pro se, they're going to need certain things, you know what I mean, and access to and whatnot, to make it fair, but also there does have to be the reasonable. So you get into this argument of like, what is legally reasonable, okay? If they were like, look, I need to be able to go to the crime scene myself, so I'm going to need a car rental and a chauffeur. You see, I'm being dramatic, obviously, but you get where I'm going. With Sarah, they've gone over and over and over and given her numerous things. Now, what's also a little bit different, and I feel like some of this would come down to the sheriff's office or the jail or whatever you call it, because a lot of this is like, that's not, like the judge is different from the jail. The jail is going to have like we have to do this, this is our protocol, boom, boom, boom. They were giving her all these other little things. Again, once she even got some of the stuff she wasn't supposed to, i.e. the box of discovery and whatnot, she didn't use it. She didn't look through it. She didn't go, she was like, she denied the computer several times. So she wasn't really using this stuff up. Now, if you go to the other end of the, spectrum or whatever you want to call it, look at Ted Bundy. He got access to everything, jumped out the window and escaped, okay? So it's like this fine line where you have to like look at all sides of it of, yes, they should be able to have access to be able to properly defend themselves. 100% I agree. But there's also a security risk, okay? And again, I just will go back to Ted Bundy. If you're not familiar with that case, this is a very good example of a man who literally continually swindled the system, okay? He ruined it for people like Daryl and Sarah. So there's that. Now, a little bit different is that, these other people wanted to represent themselves. Sarah was forced to by her actions because she kept causing drama. She kept causing drama even with this stuff. We were having hearings over a file folder and a this and a that and a boom, all the while she's not even looking at the evidence. So that's why we're in this predicament. So let's keep going and finish the rest of it out. It has been argued by jailhouse counsel that none of those privileges are granted by the Constitution and that defendants should only have access to pen and paper, envelopes, and stamps. But I would venture to argue even further that the Constitution also doesn't guarantee a defendant the right to medical treatment, meals, or even personal hygiene supplies or clothing. It's just that we, the people, have collectively decided that human rights and the dignity of the individual matter and that they supersede any constitution or state charter, and thus it is for the betterment of all to honor them, for we might one day find ourselves at the mercy of the law and its enforcers. As long as the state is responsible for the care and housing of any inmate, pro se or not, we must also afford them a path to properly exercise their constitutional rights in 2024, not just 1787, and then they sign it. I'll take their name out of this, but it's signed, concerned U.S. citizen, and just like I said, this letter, it's public information on the clerk of courts. Now, again, do I 100% agree with the person? No. Do I agree with them on some things? Yes, absolutely. Definitely 100%. We see this oftentimes in so many things going on with the Constitution, where yes, it's interpretation, it's law, it's these things. Society is ever changing. I do believe that at this point in time, sitting here and saying, oh yeah, you're going to fight your case, here's a pen and a paper and some stamps, go have fun doing your research. I mean, let's be honest, right? There does need to be some level of how do we move into the technologically based society that we live in now. Allow an inmate to represent themselves, they totally have the right to do, okay? How do we make this happen? How do we secure them and do that? So it's like the points that are being brought up in this are good, but also, I mean, Sarah was afforded the internet, the discovery, the this, the that. She's gotten all this stuff, but it's never good enough. You have to also find a balance in abusing the system. If they have these tablets, I don't even know what all kind of stuff she has, but it's like, look at Wade Wilson, for example, with the damn kiosk, okay? If there was a way to sit here and allow people to go pro se, do their own investigation, but also monitor them. And again, I think it would really depend on the state, the county, the budget, all those things. So I think this person brings up good points, but on the same note, some of it feels a little bit like, not thoroughly thought through, because again, I feel like Sarah's gotten a lot of this stuff, and it's almost like this is like an opinion piece that I can see riding the judge, but also this is more like I would also put this out in like the local, and maybe they did, right? I don't know, like local paper, stuff like that, whatever. And I'm curious to know what your thoughts are on it as well, because it's like, this is a case that's easy to make fun of and poke fun at, and it's ridiculous, it's absurd, it's over the top, the method of the crime is horrible. George suffered terribly and left this earth in a horrible way, right? Totally get that. And this has also brought up, take all the over the top, it's been 5 years, it's been this, how many lawyers are this? It brings up some very interesting things that need to be looked at moving forward. Again, it's that balance of somebody who is like, abusing the system or manipulating the system versus an authentic thing. What if this is a person who went pro se and it was like, here's your basic stuff? How would that work? How does that look? What does the law library look like in this particular facility? And like I said, I think it would probably just depend on facility to facility, county to county, state to state. So anyways, let me know what you think about this, overall. I mean, yes, it's a little bit like, but on that same note, I think that some of the points brought up are worthy of offering commentary on, offering opinions on, and how do we make this work moving forward. So I'm curious to know. Drop it down in the comment section, and also drop some little sofas off for myself, Roscoe and Spirit, our new little mascots who have been out there sleeping and being babysat. Bo William and Luke Connor, they'll make another appearance very soon. But I appreciate you watching, if you still are. And until we meander our way down to the comment section to talk about all this, I'll see y'all soon. I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Roscoe on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.